Welcome to the jungle. Yes, this is the Domain Name Law Show. Thanks for showing up each week. And if you don't, your first time, thanks for being here. Your interest in domain name law really means a lot to us. There's three hosts of this show. My name is Todd Ryan. We have Jeffrey Neuman and David Michaels. I like to say hello to my co-host before we get rolling. Hi, Jeff. How are you today?
Hello, I'm good. Excited for another good show, and um, I hope everyone's staying out of the heat in the northern hemisphere because it's a hot summer.
Okay, so you're excited about this. That's crazy. Yeah, we got some okay cases, I guess, today. A little bit of news, and I'll speak on that. But hey, David, how's everything going with you? Jeff's laughing. Okay, so we
I
couldn't hear
am.
you again. So we couldn't hear you again. Unusual. When I say unusual, I'm lying because it's not unusual. So he'll come back in. I always invite David, you can have two co-hosts, but he thinks co-hosting messes with his audio. Well, the speaker thing, that messed with it. So here he come back in. He requests. How come I can't even? I'm still going to invite him to co-host just to show him that doesn't. Don't be scared. Hey, David, are you on stage again?
Yeah, how's my audio
Oh,
now?
sounds pretty good. Yeah, hold on. I'm still gonna do it. I know you don't like it. That's why I'm gonna do it. David Michaels.
Sometimes my phone doesn't work, sometimes my desktop doesn't
I just
work.
invited you to
So
co-host. Just do it. Accept it for me. It's like an early Christmas gift. Just so I can see. Nothing's gonna change. I'm just gonna say Okay, now let's see if you can talk.
can you still hear me?
Fuck, even better.
Am
I
I
don't know
still
what
here?
happened. It sounds even better. All
Great.
right, so there's me, there's three hosts. It's just that I start the room so it shows me as the host and then my co-host. But no, we're doing this thing. Okay, so today we're going to be, I'm not going to say brief because it like goes on and on sometimes, but we got a pretty finite show today. If you have some questions, raise your hand and the lawyers can answer them when we wrap up towards the end. So we usually try to go 60 to 90 minutes. It seems like it always goes close to 90. We appreciate you being here. If you want to follow along, you can check out our outline. DNL, that stands for Domain Name Law. DNLshow.com is the website. The outline is at dnlshow.com/outline. Tried to make it real easy. And I was going to talk to the people that listen on record, the two folks. They can, anyway, check out the outline, dnlshow.com/outline. It's our 230th show today. Okay, I greeted the audience. No, I didn't really. I said thank you for being here. Thanks for being here, audience. Introduce co-host. Done. Make general announcements. I don't have any general announcements other than, well, we just do those throughout the show. Share show agenda. That's what I'm doing right now. You can go to the outline and you can look. And under B is our industry and legal news. And the very first thing was, I got to tell you, it was lukewarm interesting. It was this year's top domain sales so far. It was a DNW Podcast 546. Andrew Alleman interviewed the one and only Ron Jackson, who's run DN Journal forever. So both of those guys, they're the two journalists in our field, let's say. A lot of other sites are blogs that, show you drops from domain smoke to domain shane, right? And then, I guess I really like Domain Gang. And I like what he does over there. The reason I don't mess with Domain Insight anymore, I like the guy, but he was being a prick one time saying, hey, why don't you contribute to my site if you're going to use my stuff? What am I fucking work for you? And I'm like, what the fuck are you talking about? And this is on X. And then he's like, yeah, I didn't, well, where's the link? I don't give the other guys any money. I, go through the new. So I did, I said, yeah, Kevin, I didn't see that down there. Oh, it's at the bottom of my whatever. So I click and I contributed $50 to him. There's some, this is one time, this was probably over a year ago now, probably about around Christmas time last year. And he was just a prick, didn't say anything. Hey, thanks for that, and listen it anyway. So I don't mess with him anymore. Okay, so and I liked Kevin Murphy. I liked what he was doing, but I could give a shit. Okay, so anyway, the very first story today was DNW, and if Andrew or if Domain Gang or if anybody said, yeah, don't refer anybody to my site, but it happened like fucking happen in a minute. Okay, but anyway, so now I'm looking at DN Journal right here, and they were talking about the top 10 sales, and I thought they were for the year so far, and I thought they were interesting because the longest name on the list was commerce.com. That was the number 2 sale, which 2.2 million, and that was sold by, I guess, Larry Fisher and Larry Fisher and Ari Goldberger of Esquire. So had, I mean, brokered it, I guess. I don't know how they both worked it out. But anyway, that was to Big Commerce, who I guess is launching it now. But anyway, that was the longest one. So that's 8 letters. I say that because Icon was number 1, ICON, for 12 million. Fuse, FUSE.com, was number 3. That was Braden sold that one through Hilco. And somebody else participated in that too. And Braden was telling me, yeah, he was number 4, Sword. I happened to spend some time with him because we went down in this D3 thing last week. And it was Sword he was telling me about, 1.5 million. That was number 4 on the list. This is the top sales of 2025, the top 10. He was saying, yeah, right at the end, somebody over at Brannon's, forget the guy over there, famous guy in the domain business, but another broker. He said came in at the end because the buyer was going around to different brokers and they got all sorts of people involved. But anyway, so he's like, yeah, another broker came in at the end and they had to be broken off too. So everybody's dipping into the 1.5 million that Braden got. But okay, Sword, 5-letter. GX was a 2-letter. That was number 5 at 1.2 million. Slash, the $1 million, and I'm saying the names, you can listen to Ron Jackson and Andrew talk about them. There's some interesting stuff they mention. That's on Andrew's, podcast. But slash, 5-letter, double, 6-letter. That was a Cedo sale, 980,000. Spend was a 5-letter, 802,000. I'm at number 9, ABTC. That was that one Drew Rosner sold out of his own portfolio. Bitcoin, American Bitcoin, but 4-letter, of course. Cloud.ai was the only non.com in the top 10. That was 600 grand by, it was one of the Booth brothers. I think it was, I don't know which one. It says Domain Booth. I thought it was James, but probably was. But Andy has so many of the top .ai's that maybe it was him. And then PACK, PACK, 600 grand. Well, 1, 2, 3, 4 4-letter. I know they were words, so it's not like random 4-letter. It means anything. And then there was cloud, slash, sword, 3 5-letter, and that 6-letter, double, and then an 8-letter, commerce. Well, it just tells you short is, that is a common denominator of all these names, short. And single word names, if it's a single word and it's long, it really is, in my opinion, worth less than the short ones. People just, in domain business, you want easy to remember, less likely to F up when you're typing it in. But let me ask you first, David, what do you think about the top 10 names? Basically, this, the top 10 so far this year have already, surpassed, I guess, the top 10 of all last year. But any comments on this?
Yeah, there was another top 10 sale for $1 million. I think it was ZH.com, sold by Sato last week. I'm not sure if the letters are correct, but ZH or ZD or something like that. Anyway, it went for $1 million, sold by Sato last week. Yeah, these short names are really popular. The 2 letters are really popular by Chinese people for some reason. But then, I don't know what AI companies are starting these other things. But commerce, it actually launched last week. I'm a big commerce customer, have been for more than a decade. And they finally spent the money to buy commerce.com. They should have done it a decade ago because they probably spent more than $1 million or $2 million on their ad budget because they do PPC ads every month between 40,000 and 60,000 a month just for the phrase big commerce. And people are just typing in commerce. It has a type in traffic name. But this site now that is there, it's featuring three of their businesses. They've acquired Feedonomics, which is a way to feed in your products in your store into the Google search algorithm. And there's one other thing, it's the AI site builder. I'll test it out, see how it works. But yeah, that was a smart buy by commerce.com. Definitely worth the 2.2 million. I think they actually paid more than that according to the Q1 statement. They paid 2 point, almost 2.3 or 2.4 million because of the brokerage fees. So we'll find out what the exact price was soon enough.
Yeah, Jeff, I wanted to say thanks, David. Jeff, so Andrew and Ron were making comments. I can't recall exactly, but basically, commerce, such a general term. Is it, great to have as your name? But big commerce was already pretty general anyway. So I think it's cool. They got the dough, so why not spend it? And they liked it. But when it comes to even a huge company like that, how does commerce? I mean, how does the company Big Commerce now using commerce? How do they protect that, or can they? Other people using commerce.com in a domain name.
It's tough. It'll be very tough for them to enforce it. Um, in theory, they could, and maybe I haven't looked to see if they've applied for a trademark with what they do, but they wouldn't get it. Likely, could be on a supplemental register for a few years, and maybe like booking, they could argue secondary meaning after a certain period of time. But that's always the big uh, drawback of having a very generic name. It's a great for people to find you and to people to remember what to put in, but it's hard to protect. So, any other company out there could use the term commerce, little commerce, I don't know, whatever they wanted to use, and you can't really protect against it. So it's always kind of that push and pull, the pros and cons of choosing that generic type name. And this has been going on for, ever since pets.com, I think it was back in whenever that was in the mid to late 90s, when they were one of the first ones to really go out there with a very generic brand. They found out the hard way that, you know, nothing was stopping people from using pets to describe pets, what they do, their services. So it's been an issue since the beginning of the internet, and will continue to be. It's just a choice a company has to make.
They like it for ease of use. We have some guests on the stage. David, did you want to comment on this? And then I'll go to Josh and Paige. Hold on. Yeah, go ahead, Dave.
Yeah, so so WooCommerce tried to rebrand to Woo, but it didn't work for them. But had they bought Commerce, would have been better. Then there's like so many different variations of the word plus commerce. So fast commerce, WooCommerce, big commerce. There's a lot of big platforms in that space. A2hosting.com upgraded to hosting.com earlier this year, and they're pushing it right now. When you own hosting.com, you're in a different ball game. Like people respect you more. You're going to get the bigger business. A2 Commerce was always a little guy, and now with hosting.com, they're going to be much bigger. And I think the same will happen with BigCommerce because they've always squared off with Magento and Shopify, and they needed a way to differentiate themselves. They don't care if somebody else comes out with another something plus commerce platform. That's that's already been there. Adobe Commerce is the same thing. It's a common term. It's already been used. It's already been a problem for the last 15 years.
Commerce, certainly general, but I like it since I mean, I don't think they needed to go from big commerce to commerce, but I think it's, you know, major authority, sounding name. Hey, Josh, nice to have you up here. What's going on? That's Josh Lim for you folks. All right, Josh, no shilling anything. Are you here? You want to say anything? You're on stage. Hey, Josh.
Can you hear me?
Yeah, sounds like you're eating now.
Yeah.
Hey, what's up?
Yeah, I know. That's why I was going to wait till I finish eating. Just give me like 30 seconds.
Yeah, you got your mouth full. Hey, Paige, what's going on? What comment did you have?
Well, I appreciate the discussion, and I do believe that the getting the one word, allows the company to borrow prestige, and own that word. But I wanted to get David's take and yours on a little different question. I've been meaning to ask for a couple Tuesdays, and I usually forget. But it has to do with this idea of protecting your name. Um, so, like, say I have a name, like I own the name cryptocurrency.com with a K instead of a C. And my question is, much like you talked about commerce, trying to protect it, is the thought's always been don't do anything with your name, let the buyer do something with the name, don't put a parking page. But I'm starting to feel like with other TLDs out there that I need to be somehow proactive with this name. In this case, just to give you a specific example, cryptocurrency with a K, that I do need to maybe put some type of virtual company on there so that someone doesn't go get cryptocurrency.app, you know what I mean? And then trademark cryptocurrency for use as a cryptocurrency brand. So my question to you, David, and Todd, you too, is should I be putting something on there? And then two, is there a way for me to be notified if someone applies for that exact word for the trademark? Can I do like a notification or something? I think Chad Folkening had done this over the years. So the question is about doing something proactively so that you don't end up owning a .com. Someone gets a trademark for the word to the left of the dot in another extension, and then you're kind of stuck with a buyer pool that's restricted.
It's always a problem. So Braden used to say, don't buy up all the other TLDs, just get the .com, the one word, and then leave a path for other people to upgrade to your name because eventually they're going to want it. And so that's been one option. But developing it to some extent, I think is definitely necessary because holding costs are significant and parking is dangerous. So definitely develop it with something. It's really easy. Like I built a dictation app last night with AI Studio on Google. It's so simple. It took me like half an hour to build this whole app. It's better than granola. So anyway, yeah, definitely build. Don't be afraid. Put something on there. We're going to talk about this case today called assurant.ai. And I don't know who the buyer or who the registrant was or the respondent, but there was a big deal made about, oh, we can't figure out what this guy would do with it. And we're going to presume bad faith, like in the passive holding case, as if it's a Telstra case, but they didn't mention Telstra in the decision. They just made a new type of thing. We're saying, where the panelists said, I can't think of any legitimate use for it. And we'll talk about that later. But yeah, definitely think of stuff. Use AI to get creative, figure out what's out there, do a trademark search. I haven't had access to Chad's platform yet to do a trademark alert service. I'm trying to build my own so that it's going to work for me in a different way, a lot more proactively. There are a few services
Yeah, well,
out
I
there. They're
appreciate it. Yeah.
expensive.
I know I see Jeff up there too, because I feel like if someone does start a company with the same word that I have the .com, they can apply for a trademark, and if I don't know about it, then I guess if I'm doing something, they have to at least admit that they knew about me when they started. I'm trying to figure out how to be a little proactive. I don't know if Jeff is with us or Todd. What do you think in terms of not waiting until someone gets a trademark on another extension and then you're stuck, but doing something now?
Well, I mean, I could talk, about there are a lot of companies out there that do watch services, trademark watch services. It used to only be companies like Core Search and Thomson Reuters, Clarivate. There's a company called Trademark 411. So there's a lot of Markify, I think, is another one. So there are a bunch of them out there that you can. It is kind of expensive if you can't build your own, But brands do that all the time. I mean, you know, I'm sure Mark Monitor, CSC, they all have those kinds of services too, um, because
And Jeff,
that's
if someone else does apply for a trademark and I'm doing something on the .com, can I contest it or submit something? Do I have to wait till it's fait accompli that they have it, or can I submit like, no, I don't think they should be given it?
So what happens first when someone applies for, at least in the U.S., someone applies for a trademark, their internal teams will, the USPTO will analyze the mark and see whether it's one that could qualify for a trademark and whether there's other marks or other things out there that it may conflict with. But then if the trademark office says no, we think it's fine, then it gets published. And when it's published, that's when you have 30 days to object to the trademark based on prior use or anything like that. That's the point in which you'd be offered an opportunity. But I'm not sure if you register a domain name, I'm not sure how worried you need to be about someone else filing a trademark on it because you acquired the domain before anyone else did. Um, sure, it's going to depend on what, if you want to sell it, it's going to depend, if a buyer wants to come in and use it for a specific purpose, then it's the one that has to do a trademark search to make sure it's not violating it. But your just pure ownership of the name prior to anyone else getting a trademark is fine. You don't need to start, a make-believe service just to get a trademark on it.
Let me say,
Guys,
but
I
Paige,
finish
hold on, Josh,
eating.
hold on. I want to say
Sure, sure,
something.
sure.
Um, Paige, it's a great question. And one, the service that Chad has, dntrademark.com, it's not going to cost you anything. If it does, let me know. But then you can get the notifications. But what he's asking Jeff is, yeah, cryptocurrency, okay, with a K, and a great example too. So cryptocurrency with a K, he owns the .com. Somebody comes in cryptocurrency and he wants to, he knows likely on that name someone's going to offer a meme coin or some kind of crypto, and he wants them to be able to, that buyer, that's his big buyer pool. So then somebody comes in and starts offering a pump fund or just something really related to offering a coin, a cryptocurrency on cryptocurrency with a K app. Then it does limit what he can do. Basically, a potential buyer can use the name for, and that's the big concern. And Paige, you're right on. This is Chad been yelling about this exact thing for years, especially having great generic names and then somebody else coming in and trying to limit what you can do with your name. Because there's the obvious with cryptocurrency with the K, there's the obvious class, and I don't even know what it would be, but the obvious class that you would think someone would want to use that
Well,
name
look,
for.
nobody's going to get trademark rights in cryptocurrency with a K, right? That's what the U.S., at least at the U.S. Patent and Trademark Office, they monitor sound. They will consider a sound alike to be no different than the actual term, right? So it's
Well, that's
Well,
not
okay,
I
true
would
with
I
maybe I took
Lyft.
the bad example. Say I had crypto. Say I had with the C. Say I had cryptoopia or some. Just I'm trying to think. Todd, you really nailed it. Was this idea that you have a name that's a brandable, like we like to call it brandable, but it's not as much an open C brandable for anything. It really hints at one use case. You know what I mean? And so you really nailed it, Todd. That's what I'm after. So
well,
whether you
yeah.
cover
I mean,
today or yeah,
fir- first to use a mark is the one with the rights to it. So if you just if you just have a brandable name, but you're not doing anything with it, and then someone comes independently and just launches their brand, um, they're gonna obtain rights based on their use. Now, they won't be able to come after you for having the domain name, but yeah, in theory, it could restrict the buyers from that. Um, it, and their ability to use it. Sure, happens all the time because trademark law is not about taking a mark and taking it out of circulation for everyone. It's about being the first to use it. Um, there's intent to use, which is another category, but it's essentially there's no reward that anyone gets for owning a domain name and not doing anything with it.
Well, I really appreciate this forum to be able to talk about something like this. I'll disclaim everybody that I did not ask for, nor are you providing specific legal advice. This is generic, and please consult an attorney and everything. But I think this idea, even though you guys analyze cases, you know what I mean, of talking about things to do now, I'd love to see us go down there. And I hear what you're saying about first to use, and it's going to make me think about a couple of my names and try to establish some use. Like you say, no one can take the name away from me, but at least I can maybe protect the buyer from. Can they buy my right to be first to use? Like, do they inherit that if they buy the name from me? If I'm running a company, a virtual company selling T-shirts or a blog or something, and they
Yeah.
buy,
So
do they
yes,
inherit my first to use?
yeah. The way you would structure it is not a sale of the domain, but a sale of the company that happens to include the domain. Then if they are doing the same thing that you're doing or building it out, then yes, they would inherit um, your your business and your rights, but not just for the domain. You'd have to actually sell them the business.
Yeah.
So
What Meta did when they bought didn't they buy Meta from a anyway, I won't confuse it with that. But thank you so much, Jeff and Todd and David. I really appreciate it.
Hey, thanks, Paige. And Josh, before we get to you, Josh,
Hi.
hold on. I got one more thing to say on
Okay,
Paige.
okay.
There's one thing you can do, and you know this, with cryptocurrency with the K.com. One thing you can do is say if you set up you turned on DNSSEC, you enabled it, and then you mapped it to a wallet, and then you even sent crypto to it. Now we could help you at Pay Now. We do it for you. But my point is because you can't just. What I'm saying is this would help establish a mark by saying, look, we've received payments to cryptocurrency.com, a crypto payment. Now that's only one small piece. Of course, you could get an LLC, a Dow LLC created in Wyoming for $100, a little bit more than that. And all these things would assist. Of course, you still need it. What is the business? What are you doing? But I do like the idea of being able to, as domainers, get a payment to that domain name. That is helpful later on. It's only one small piece. What is the payment for? What is the service or product? What's really going on? You can't just do something sneaky and then think you got a mark. But as a domain, I've always loved just registering a domain name. Does it is important to add that to your evidence. You've had a domain name, you've had payments on it, you might have a DBA, and these things are just part of doing business. Of course, then they want to know what's the real product and service. Okay, Josh, but Paige, I love the question. We'll talk about it more sometime, definitely. Hey, Josh, nice to have you here. Thanks for being patient. What's going on?
Thank you, thank you. So this was something I was looking into just today. In my country, at least, right? The thing is, it's actually possible to take over the domain name and take over the company if it wasn't shut down properly. Do you
Well,
get what I mean?
yeah. Let me
Like
say,
basically to wind up the company, or if they didn't have a meeting and then it's stagnant, you can actually buy it over. So technically you would own the what lah, basically. But another thing that I find really interesting is Malaysia is the only country in the world where we have the extension .com. Like instead of Sendirian Berhad, instead of private limited, it can be like yourname.com. .com is the actual word, the extension for it.
DOTCOM.
Yeah, DOTCOM, basically. Because, I found it really funny that, some companies, although they don't own the .com, they call themselves, like yourname.com, But I then realized like it's interesting also that Malaysia is one of the cheapest countries in the world to launch a UDRP suite from. So, like I really wonder whether someday people will try to challenge it, like, okay, because I registered the business and the business name is .com, I can own the .com. I don't think it'll hold up though, but
No,
it
it
should be
doesn't hold
interesting
up,
to
and
see
it's
them
real
try.
confusing. Sorry to talk on you. It's real confusing.
Yeah.
And normally, I wanted to tell everybody, normally at the end, if you have questions or comments, you can come up here. I appreciate Josh and Paige coming up here. But I wanted to say about, I always hate when someone says I wanted to say. I say it all the time. Hamburgerhamlet.com. Okay. Hamburger Hamlet was a place, Paige knows it, out here in LA, had it for years. It went out of business. Well, when it goes out of business, and they don't lose their trademark the day they stop selling hamburgers, although you could make a case that they do. But usually there's a little bit of leeway, right? If you stop doing the business, you have
3
a little bit
years.
of leeway. Go ahead.
3 years.
Okay, so that's a
3
lot of
years
leeway.
is the
36 months.
presumed abandonment period.
But still, Hamburger Hamlet, when they sold, they stopped doing business. But when the name, somebody picked up the name. Of course, you're probably going to be in the hamburger business, right? Now, if they don't resist or they don't cause you problems, you can really just go right into their business. I think they even filed bankruptcy. I don't know if that would affect it, but I guess my point to Paige and to Josh is yes, and Jeff said it. I'm just repeating what the lawyers are saying. Of course, you can assume somebody's IP, and especially if you still have it, still have rights to it. You're like, yeah, so I'm selling you all of our intellectual property. There may be some copyright materials on the website or documents, so they could say, I'm selling you all this stuff. And if they have any patents, of course, you could buy all, sell all that stuff with it. But Paige was specifically talking about trademarks, and you absolutely can sell the trademark with a domain name, just to include it. And of course, user handles, anything like that. All right, we have a pretty big outline today. It's not even that big. I'm just bullshitting. Okay, so DNL. So we went to the first one. The second one, real fast. I'm not even go through it, but I guess .med is going to be available. Medical branding. It's the extension .med. I just saw an article by Encirca. I guess they're going to be one of the registrars that offer it. But David, Jeff, you guys hear anything about this .med?
It's a relaunch of a TLD that's already been launched. I'm a little bit curious as to how there's some contractual requirements that they're supposed to only delegate names through requests for proposals as opposed to registrations through registrars. And I haven't seen an amendment to that agreement. So it'll be interesting to see what ICANN does if this is brought to their attention, because it's not in compliance with their agreement. But yeah, I mean, it's just someone else taking over. It's essentially Encirca taking over a bunch of the marketing and stuff and trying to relaunch it. But I looked at NTLD stats, and there's 30 or 40,000 names that have been registered by essentially Encirca itself. So I'm not sure what they're doing there. It's yeah, haven't been able to figure that one out yet.
Interesting. Yeah, you can see why people that would like to go ahead and take, if they have say there was no premium registrations and they went ahead and purchased them and then they turn them into their own premiums. Basically, they can do that privately. So, Jeff, let me ask you about registries, because I know I've heard of all sorts of different things happening, but a registry can reserve names and offer those as a premium. This is prior to whatever agreement they have with a registrar. So I'm talking about a registry in itself can reserve premium or names for premium, but you've heard of, or have you heard of a registry like setting up a separate entity, a separate company, and then buying the names? Sounds like what Encirca did, but buying the names and then they sell them or auction them separately from the registry, but really connected, just sort of a workaround.
Yeah, I mean, in theory, registrars, they're not, well, they're not supposed to warehouse names to do that, but things like that have always happened, right? I mean, Two Cows years ago, and one of our cases deals with this, bought what 70,000 surnames that they would then essentially resell services to. Yeah, you can in theory do that, but it's kind of expensive for registrars to kind of engage in that. But yeah, registries can reserve names to um, sell, auction off at any time. I mean, so long as it hasn't already been registered.
Yeah, if they don't, it's almost a mistake by a registry not to reserve some of their names. Who doesn't do that? Paige, what question did you have?
Just a thought. I think this is indicative of what we'll see in a lot of the new TLD apps. Because I think the key here, as I think about being a TLD marketer, for LA and the work I do with CFD, is you have to try to do it in a way where you don't have to pay the registry operator for it. You know what I mean? And at the same point, if I can't get their 21 cents, I think they're probably going to be okay with it. So if you could create an entity, buy all the names, and then be the sole marketer. I guess you're moving beyond the registry agreement once you buy the names as a registrant. You know what I mean? So I think it's different than the registries reserving names. They have some room to do that, and I think it's different than setting up premium naming structures, where you don't have to buy the name, you just charge a premium price. And I think that it's something we'll see more of. And then on this topic, Todd, I don't know if you have it in your news, Amazon also announced that they're going to try to get some more out before the window, before the next round. So I think you're seeing kind of an emptying of the cupboard of the generics that were approved but never issued.
I think it's interesting that they do it not necessarily in a laddering method, but right, sometimes when, like in this next round, you're not going to have a bunch of people apply. Whoever is successful, then they all just release their names at one time. Some own them, and then they release them a little bit later. Before we move on quickly to our cases, so we can get rolling, what are a few of them, a few additional ones Amazon are unloading or basically releasing? Paige, anything?
I think .free was one. I'm gonna give Andrew Alleman credit here. I think he had an article on Domain Name Wire. .free, and I'm stalling here as I look up his news.
What was that first one
Well,
you
I
said?
don't. .free.
Oh, .free, and yeah, I remember free, and now it come to mind that
I think dot spot dot. There's a bunch of them.
yeah,
There's
spot,
probably like
hotspot, or not hotspot. Maybe it was hotspot, but one was spot and one was
there's
hot, maybe even.
maybe I think essentially there's like they applied and got like 50 something. Well, maybe it's only ended up being like 30 something TLDs, but yeah, and Google's launching all of theirs at some point. But yeah, but this is not even a launch .med. It's a relaunch because it was launched years ago.
Okay, a couple other pieces of news. Well, basically, I wanted to let everybody know, if you're not a member of the Internet Commerce Association, it's not my job to say join. I'm a member. Jeff's a member. Dave's a member. Paige is a member. I see dozens of people in the audience that are members. We have, there's a lot of reasons to become a member of the Internet Commerce Association. If you want to know why, go to internetcommerce.org. But I'm wanting to share that on August 20th, that's a Wednesday, we're going to have a summer social. That's where we all get on a Zoom call and we look at each other and we wonder, why is Siger so sunny? He always looks like he's on vacation, but yet he lives up in Washington State. Doesn't make sense. And then his teeth are whiter than they were. Every year they get whiter. Okay, so enough with Mike. But anyway, we all get on a Zoom call and it's a fucking good, excuse my language, it's a good time. You get to see everybody before we cross paths with everybody at the January meetup. But I just wanted to mention, yeah, if you want to be part of that Zoom call, I'm sure you're just like thinking about joining. It can be as little as $25 a month. It's well worth it too. I got to tell you, for the monthly AMAs that we have with industry leaders, and then just the contacts that you make, because it's a bunch of domain investors primarily. That's probably makes up the most of the membership, but then there's a lot of lawyers. You can't stop the lawyers. And then of course the vendors GoDaddy, Dynadot, NameBright, TurnCommerce, of course, those guys. But you just get to really rub elbows. This may not be important to you, but basically a lot of the companies you do business with, and then of course all the brokers, and that's important as a domain name investor because you'd like to meet them face to face and say, do you really have any interest in helping me out with some of these names? And believe it or not, I think brokers are going to be needing us a little bit more than they have in the past, meaning, usually they used to like those single word names where there's a lot of incoming leads. Now they realize, they really need the domain investors. And then I'll finally say once again about the domain investors, we need more domain investors as members of ICA because we're the ones that need to say, we're tired of this marketplace, or we're unhappy with the rules here, or these prices being raised, or some things we can't step in front of. Registries, can do what they want with pricing, but if we have complaints or we have issues that we want to try to resolve with a registry, and there's registries that are members or registrars, it's better in numbers. So think about joining the Internet Commerce Association, and there's a link on the outline at dnlshow.com/outline. You can email Kamila. She's the executive director, and just say, hey, I'd like to join. Todd said it's 1 month free. Oh, she'll do something for you. But anyway, like to see you guys on the call. For you guys already members, yeah. See you on August 20th. I'm sure she'll be sending out a link here, in the next couple weeks. Did you want to say something, Paige? You were off mute. I know that hand's probably stuck up, but no, he's cool. All right. And then the last thing I wanted to say, not last, we're going to go to our cases, but later on today, 4 p.m. Pacific, 7 p.m. Eastern, which now I realize is pretty screwy for the European friends of ours. Some people overseas, I guess if you're really far away, Australia and Dubai, it's tomorrow, so you'll still be able to participate in this. There's going to be a live domain auction here on X. Aaron, Laser AI, he's known by here on X, had a pop-up auction the other day. It went so-so. It was nothing great. But anyway, a lot of names for next to no reserve. Sure, a lot of them are ones that your fellow domainer plans on dropping, but his trash may be your treasure. And I was offering some names that I didn't plan on dropping. They weren't my best names, but I was offering them at no reserve. And a couple of them went for $75, so that was pretty cheap. Some of them went for even less than that. But that's going to be today. So check out, I think I posted it on my timeline. You can see we're having a live domain auction here on X. If you have never, been participated in one, join and listen. It's somewhat fun. I'm not going to, no holds barred. I'll probably be pretty rude to the bad names if I hear any. Okay, so that's going to be today, 4 p.m. Pacific, 7 p.m. Eastern here on X. Now we're going to jump right into our names that we're going to review. These are UDRP cases that are all pretty recent, decided in the last couple weeks. This first one is Tyrone.com, Tyrone.com. Pretty cool first name, Tyrone.com. The complainant in this case, Corcreevy Party, I don't know what they're out of Australia. Corcreevy. They're a big masonry company, but basically a construction company. But I say big, only really 60 employees. But they're going after domain admin, anything.com. And Jeff mentioned it either. It's basically 2 cows. So 2 cows is the respondent in this case, and I didn't even know. Are they now out of St. Kitts and Nevis? Is that where they're out of now? Jeff, do you know?
I mean, that's not where 2 cows is out of, but they may have, yeah, exactly. But they may have incorporated a company there. They may have bought some of these names from, actually, I'm trying to think of where the original company was that they bought it from. But yeah, no, 2 cows is still a Canadian company, but they, like I said, they may have a subsidiary there.
Okay. I mean,
So,
yeah, maybe.
so Corcreevy is with the Tyrone.com case, and Pete.com is with 2 cows. So I think I got these 2 mixed up.
Oh yeah, you're right. I mean, you're right. I got it all on one page, and I looked down at the bottom. So right, this is anything.com. Excuse me for the mistake. everyone listening, the complainant in this case is Corcreevy out of Australia. It's they do business as Tyrone Masonry and also Tyrone Group. So they think they have right to the name Tyrone. And they're a construction company, not that large, 60 employees. It was these cases, what's familiar is they both, and we see it a lot in these UDRPs, the respondent always is under domain admin. So it's like they don't have the name, and this one is anything.com. What I do know is Jason Schaefer from Esquire.com represented the domain owner who owned Tyrone.com. So I'll just mention a few facts, then I'll go to David and then Jeff, as I can tell David has a few things to say on this. Is the disputed domain here resolved to a for sale landing page. You click on a link, it sent you to GoDaddy. The complainant in this case said, the respondent acquired the domain sometime from 2022 to 2024, which, spoiler, that's inaccurate, but that's what the complainant said. And it really didn't have proper evidence to show it, but that's what they believed. And they said, the disputed domain name was bought and sold 4 times because he saw changes in the records from 2016 to 2024. And I put in my notes, they claimed, the complainant claimed the usual BS, and that is, they're not known by Tyrone, the respondent isn't. And they, passive holding is evidence of bad faith. And they have no legitimate business on this. They have no real interest in here. So they came up with all the basic stuff. Unfortunately for them, this was represented by a domain name attorney who knows how to answer a lot of that. So David, I'll go to you. Talk about Jason's response and the decision before you throw it to Jeff.
So the complainant actually put a lot of false statements in their complaint. So Tyrone.com does not resolve. Right now, if you go to its bad gateway, it's been that way for a while. The complainant said that GoDaddy had it listed for sale if you paid $99 to a broker or whatever it was in their window. I see $99. But GoDaddy does that for every domain name that is not listed for sale on their platform. So these lawyers who filed this UDRP complaint are incompetent. They don't realize that when you see the message, domain taken, Tyrone, we might be able to help you get it. See how? Broker service fee $99.99. Buy it now. Well, you're buying that broker service fee. You're not buying a domain name. So anyways, GoDaddy does not have contract to sell any of these domain names. And, they just do that for every single domain. You can type in here bofa.com. It'll still show you that they can, you can hire a broker to go get B of A. So
yeah, so this
anyway,
one, you're right that Tyrone.com doesn't go anywhere, but www.tyrone.com does go to this search page and a page that says this domain name may be for sale. Contact anything.com Ltd to inquire or make an offer. And then if you click on that, you get to another screen, a GoDaddy domain parking for sale page. So, yeah, I mean, so they do have it there. You just have to do it at, I guess they entered their A record at www.tyrone as opposed to just tyrone.com, which most people do both. But yeah, I agree. I mean, they didn't, there was no evidence of anything, and there was no evidence of targeting. Obviously, they were wrong in the fact that they said they thought that the whois changes that were in, I guess, their domain tools report or wherever they got it from, basically they equated that to being a change in registrant when 99% of the changes, okay, maybe that's too high, but a good high percentage of changes to domain records have nothing to do with registrant information or who the registrant is, but it's normally associated with records, whether it's adding MX accounts, modifying MX accounts, A records, C records, all sorts of things, DNSSEC records. But IP attorneys now are starting to just make that argument in every single complaint. Well, I noticed the who is was changed, so that must have been, that this new company acquired it, which it's not correct. And they should have known it's not correct, because I think this is the one where if you had done a historical search, you would see that they've had, they provided records that it was clear it's been the same anything.com owner since, I think they said it's at least 2016, but most likely way before that. And so
2004, actually. But
the panel obviously found in favor of the respondent, because if you register a domain, as we all know, prior to the trademark rights existing, you win. And I think this case also said, I'm just trying to double check to make sure, for completeness, yeah, they did say that, domain names, holding domain names for resale, of common words or common phrases, names, acronyms, dictionary words, can be a bona fide use and is not per se legitimate. So they didn't have to say that in the decision, because obviously they could have the panel could have just stopped at, the domain was registered before the trademark rights accrued. But I think it was good that they, for completeness, went on to say, and even if that weren't the case, resale of domain names is and can be legitimate. And then they went on to find reverse domain name hijacking, which is good. Good result all around for Jason Schaefer and his firm.
Okay, so the domain we're talking about
Also,
is
the
Tyrone.
complaint
Go
only
ahead,
got
David.
their trademark last year. Sorry.
Go ahead, Dave.
Yeah, they only got the trademark registration last year, and they're making these wild accusations with no basis. So that's why they got the RDNH. But Jason went further and said, if you go back, 2004, 2011, you can see on the Wayback Machine that it was owned by, like, it says here, your source to virtually anything, exclamation mark, and there was like a page there. Apparently there's supposed to be an email address previous to this, maybe back in 2004, but the respondent says they acquired the name in 1998, but they can only prove that they got it in 2004. I guess they're missing the receipts from before then, and that's quite possible. I don't think I have my receipts from 1996 either, so I wouldn't know where to look for that.
Yeah, you're right, David. So what happened, we're going to sum up this case, Tyrone.com is the domain name. This complainant out of Australia has this masonry company, and they went by Tyrone Masonry and then Tyrone Construction. They've been doing business really since, I don't know if it was 2016, but they really didn't get their trademark till 2024. But the bottom line is they said a bunch of stuff that they didn't have evidence for. They were saying this domain owner got this name recently, it's changed hands so many times, and they have no rights or legitimate interest to it. When the respondent got the case and hired Jason, he slowed it down and he said, first of all, the respondent is in the business of registering domains for investment or development, either one. The respondent looks to develop or sell to entities that want an easy to remember domain name. So he starts laying out that, investing in common names, dictionary words for resale is a legitimate business. It's a, especially, and they put in the caveat, especially, as long as you're not targeting a trademark holder, because you can get a generic name, but if the very first thing you do is contact the trademark owner and try to sell it to them for a lot of money, and you say something stupid like, you're the only person I knew, you would be the one that would want this, I got this because of you, and you just flat out are that goofy, and even if you're targeting, even with the generic name, you could possibly and probably likely lose it in a UDRP, because then they're going to show you bought it and here's all this evidence that they targeted. But what Jason was saying here is this person, has other, buys names like this. And then he also had some evidence. The respondent, Jason, was saying that these names sell. What I thought was unusual, Jeff, that Jason put in here, the domain resolves to a PPC page where the provider software selects the links and the respondent has no control over that. This was a 3-member panel and went all for what Jason was saying, but there's some panelists who believe they believe you are responsible no matter if the provider selects the links. Am I right there?
Yeah, I mean, there are a lot of um, panelists that believe that you're responsible for what's on your site no matter what. I think over the years, there have been a few more that have kind of come around and said, okay, yeah, GoDaddy puts stuff up on the page automatically. Um, if it's only been a couple months, maybe you just haven't gotten around to putting up your site yet. I mean, there are some that are much more understanding, but yeah, it's still very common for GoDaddy to get um, registrants into trouble because they're putting links up there, making money off of it. Registrants not making anything off of it. Registrant 9 times out of 10 doesn't even know what's up there. And, all of a sudden now what GoDaddy's doing is getting their registrants into trouble. But we're starting to see a few more um, panelists come around, especially when the respondent's attorney or the respondent puts in information about it, right? So many panelists wouldn't on their own go look at it to see if it was a um, registrant or registrar page. But certainly if you have an attorney or someone that knows what they're doing and responds and they put it in there, yes, there are panelists that will consider it. But you're right. The bulk of panelists still say you're responsible for what's on your site no matter what.
We have an interesting case coming up. I wanted to finish with that case saying that was a 3-member panel. The chair was Jane Seeger. Luca Barbero was one of the wings, and Jeremy Spears, and they ruled complaint denied plus RDNH. They felt like this complainant should have known they couldn't win the case, especially because they were providing all sorts of evidence they couldn't back up. But then they felt like, hey, very simple, you should have known that this name predated, the registration predated your mark, and there was no targeting at all. This next case is also a 3-member panel. One of the unique ones, 3 women were the panelists, and that's just unusual to have. I don't even know what the percentage of women are as panelists, but that's the first time I've seen 3-member panel, all women. I liked it. Okay, the domain here is peet.com, and since I mentioned Stephanie Hartung was the chair, Deanna Wong and Sally Abel were the 2 wings in this case. But once again, the domain name peet.com, registered back in 1996. Interesting about this, the complainant in the case, Peet Limited, once again out of Australia. Well, these people just don't want to pay for the names, huh? And they think, so anyway, this company was different than the last one. Is Peet Limited is a land developer, been around since 1895. It was, founded by J.T. Peet. So yeah, the guy's last name, which is obviously other people's last name. Isn't there a Peet Coffee? Yeah, pretty big. I see it at the stores. There used to be at, coffee shops.
Yeah, that's
Peet.
big. Yeah, Peet's Coffee, yeah.
So the respondent in this case, once again, says domain admin, but it was 2 cows. And sometimes it says 2 cows, and you're thinking, was that the registrar? Well, that was the actual owner as well. John Berryhill represents this respondent. So we had Jason Schaefer, and in the last case, John Berryhill. In this case, I bring it up because those 2 great domain lawyers, because they're actually in the trenches right now. They're constantly, taking on cases. They're not like some attorneys who've done a lot in the past. They're basically still doing it every day. Every week we see them with cases. They're going to be joining Jeff and I on a panel at NamesCon where we're going to have sort of a mock trial, but we're going to slow things down, a mock hearing, I'll say, where we're going to slow things down so we can talk about the different points and nuances of UDRP, and so people can learn a little bit. But look forward to having Jason and John join us down at NamesCon. But okay, so John representing Two Cows in this case, and Two Cows, of course, the Canadian registrar. The complainant is on the domain pet.com.au. Okay, so they bought it in 1996, so they were early, but yet this domain name pet.com was registered in June of 96. So I don't know if the complainant at that time it would even wanted it, but they at least were early with their own name. I'll just give one fact and then throw it to you guys, and that is the respondent. Well, I already said it was Two Cow. I think it was very interesting. It was. I'll just say the number was 17,000, not 70,000 in this surnames they picked up in 2006. But Jeff, to you, tell us a little bit about the facts of the case that from the respondent standpoint.
Well, yeah, I mean, so from the respondent standpoint, there was a company called mailbank.com that owned the 17,000 names. Two Cows was looking for additional services to offer back in 2004, 2000, yeah, it's either 2004 or 2006, when they, purchased this company Mailbank, and then decided that they would offer email services to people with these last names, so that they could have, in this case, John.Pete or whatever his first name was, or sorry, John at Pete.com, Jeff at Pete.com, Todd at Pete, and so back in the early 2000s, there were a lot of people that signed up for these services because they knew they couldn't have the .com to themselves, but they kind of liked having their last name, .com as their email address. Two Cows has had that business since, like I said, 2004, 2006, but we haven't heard too much about it for the past decade or so. So I'm not sure how well the service actually does anymore. But presumably they still have some revenue, and I think Hover, one of Two Cows' retail registrars that they own, is the one that actually manages the personal names. So complainant in this case brought the case based on the company that you described, Todd, where the owner's last name was Pete, and said essentially the typical that the respondent has no legitimate rights. It also, I think, lied, or it said that respondent appears to have acquired the name on February 20th, 2024. And they say that's evidenced by an ownership data extract, which turns out not to be the case. The respondent John basically acknowledged that, okay, yes, these guys do have a trademark, but the term Pete is a common surname, as the founder of this company, James Thomas Pete, suggests. I thought that was great to point out. They correct the record and say, no, this name was actually part of the portfolio that was acquired in 2006 from Mailbank. And that what the respondent was referring to was, again, another Who Is history record that changed, not due to a change in ownership of the name, but for something else. I don't know if they said what it was actually for, but it was not that the respondent acquired it in 2024. And then they brought a whole bunch of records that they had about the acquisition, about the names that were there. And so, yeah, I mean, it was pretty clear that the panel at the end of the day said, we see, we see this as a legitimate business. They didn't acquire this to the name to target this Australian company, Pete. The fact that they use this the same way they being Two Cows, use it the same way they use the 16,999 other names is legitimate. It has nothing to do with Pete. and that there have been other domain cases that have recognized that this is a legitimate service. Interestingly enough, there was one case in that in which the court or in which the UDRP panel found that it was not a legitimate business, but it turned out that that UDRP case was challenged in court, and like a couple weeks after the filing of the case, or after the respondent responded, it got the decision in this court case. And so it submitted that decision as a supplemental filing, which the panel accepted because, again, this is relevant to the case and it was only known after the initial papers were filed. And so the complainant's one case that it cited to that Tucows lost actually was overturned with this court case. And so, I thought that was interesting timing, and great for John, and great that they filed it, and great for Tucows. So, yeah, I mean, at the end of the day, the panel found in favor of the respondent. There was no finding of reverse domain name hijacking. My thought is that John doesn't usually ask for reverse domain name hijacking. He just expects panelists to bring it up on their own. And a lot of times panelists do. This panel, for whatever reason, didn't bring it up on its own, and so didn't find reverse domain name hijacking, but I'm not sure they even considered it.
John focuses on winning the case, not asking for additional stuff. But and I noticed that in some of his cases as well. David, not much meat left on the bone. There's still a couple facts in this thing I was going to throw in, but what do you have to say about this? PEET.com.
Yeah, so the marker case that was cited against Pete.com was in 2012. And had they gone to canley.org, they would have seen that there's an ongoing case involving Tucows and Marker Vocal over marker.com. And there was a decision in 2017 on a motion to dismiss. The respondent or defendant in that case said, well, we don't think that this court has jurisdiction to challenge a UDRP order, and we bring our motion to dismiss. And the court said, nope. And there was a decision that it's not dismissed, defendant's motion is dismissed, and they had to pay costs of $5,000. And I'm surprised the case went on, and it was finally resolved until a couple of months ago. So now we're in 2025. It was initially filed in 2012. So that's a 13-year lifespan for a UDRP objection, going to court. That's what it takes, 13 years. So I think that people should stop trying to go after names that they're going to lose on appeal, especially if there's mutual jurisdiction in Canada, because the courts here are slow, and they're slow but fair usually anyway. So Tucows lost the runner case in the lower court, but then appealed it and won in the Ontario Court of Appeals, so that was good. And no, sorry, they won on both ends. They won in the lower court, in the Superior Court, and the Court of Appeal in 2012. So, yeah, and they've litigated a couple other cases. So I think that people should stop filing UDRP complaints against surnames, against Tucows, because surname businesses are legitimate. I see that I can get my email here, david@pete.com, for $35 a year. And you know what? I don't have a need for Pete, but maybe something else. But the complainant said, hey, wait a minute, somebody else could be using their name at Pete.com and impersonate us and commit fraud, and it's a risk. We can't have that risk. And the panelist says, sorry, the mere risk of the respondent's customer is creating an email address with the intention of imitating an employee of the complainant to do unlawful activities does not turn the response email service into such bad faith undertaking unless there has been evidence of such intentional use orchestrated by or actively involving the respondent, which the complainant has not provided. So I guess domain owners are not fully responsible for everything that happens with their domain names. This is one of those exceptions. I hope this is extrapolated to other things like malware injected on your website or ads injected onto your website by the complainant himself. So yeah, that's what I wanted to add.
Well, we had the two cases so far, Tyrone.com, first name, PEET.com, last name. In both cases, the domain owner gets to keep the name. I will say in the second case, Pete, so it was, right, Two Cows bought in 2006 these 17,000 surnames for 18 million bucks. And in the case, I guess John put, I don't know where they came up with this number, but that was 68 at the time, 68% of the US and EU surnames. So that's quite a bit. And that's when they started in 2008. A couple of years later, Two Cows started this personal name service where they had up like 39,000 of their names. I guess anybody wanted an email address, and we'll get to our last case, but I want to say, David, you've had so many issues with your own last name, Michaels. Maybe you should just change it to Pete, get that email address, and go. Well, tell us real quick, what's going on with Michaels. Was it CA or Michaels.org? That was a case that someone took a name from you. Any updates on that? What's going on?
So Hover actually owns Michaels.org, so I don't have that. And no, I wouldn't want to go with the .org email address because even with my davidmichaels.org email, I lose a lot of emails. People send emails to the .com version, so it's better to just use something else that's simpler. And a lot of people can't spell Michaels. But my Michaels case in Canada, I still haven't moved forward at this point. You need money, right? This is a long battle, and I need to go through Superior Court to invalidate the federal statute that gave jurisdiction for the federal court to transfer the name, and that's going to be a big battle. So, you have to prepare for that.
Yeah, a lot of people want to spell Michaels with no S. Michael. It's Michaels. It's not George Michael. It's David Michaels. All right. So, by the way, there's been 32 reverse domain name hijacking cases so far this year. We're on a record pace. Okay, congratulations. There's no penalty to it, but at least panelists are finding that, a lot of these complaints are being brought, say, recklessly or abusing the system, let's say. Our final case today, and listen, if you have a question or comment for the lawyers, raise your hand now. We'll have 1 or 2 minutes right after this. We're going to get through this last case quick. So raise your hand and you can come up and ask the lawyers something about domain name law. Do you get a cease and desist? Or, you're scared to death. You bought a name and it's, somebody else's name. All right. So this final case is Assurant, ASSURANT.ai. I included this because the complainant in this case was Assurant. I guess it's that insurance company. I know it is, but I don't know, is it Assurant Incorporated or International or whatever their name is versus Admin, once again, a pork bun. But this company, we've all done business. We're probably all customers. They have 300 million customers worldwide, but they're this company. It's like an insurance company, but they provide these insurance products for the insurance companies. But anyway, risk management for auto, life, home, everything. So like I said, there's 300 million customers that deal with this company worldwide. They have 13,000 employees. I'm surprised they're only in 21 countries, but we've all heard of Assurant. They're on assurant.com. They've had it since 1999. What I knew this was a word before I saw the case, but I was thinking, as the more I was looking at it, I was like, maybe they didn't make up this word, did they? And then as I did research, I see, no, it's an English word. It's not used much anymore. It's more old English, as they were saying, but it means just what you think. It's like assuring somebody. It's like assurance, I don't know. But it is an English word. It's just not used that much anymore. So that's why I felt like this domain owner has a right to this name. But in this case, the domain owner did not reply. So this big company comes in and just says, hey, they have no rights to it. We don't know what they're doing with it. They haven't no legitimate use. We can't imagine what they're going to do with it. Surely they've heard of us. We're so big. By the way, we did win assurant.work recently, and that name didn't resolve, and just like this one. But basically, they made their argument. There was no reply. Robert Badgley, who was the sole panelist, said, sounds good to me. 1, 2, 3, you've met all the prongs here, and I'm going to transfer the name to you. David, what could have happened here? I mean, how if they did answer, if the respondent did answer, what would be the best response to try to save this name or to hold on to it?
So the domain was registered in 2023. And so it is a little bit of time, but guess what? AI businesses were really nascent back in 2023. There was barely an LLM out that was available back then, but now there's like you can build sites in minutes. The thing he should have done was built something that was not that doesn't have anything to do with this Assurance Inc. company. I've never heard of them before. I had to look them up today to see what they do, and I'm still not clear, but it looks like they do reinsurance and they do some sort of technology monitoring of your home. I don't know. I would have put something on here like for a fact who is check service, because you see all kinds of stuff on social media and your friends tell you X, Y, and Z is true. And is that really true? And this you need an AI that can figure things out. And there's also a big problem with AI hallucinating when it's creating code and or making flaws in the code where there's a way to game it and then crack a site. So if you had a service that was assuring developers that, yes, this code is good, it's safe for publishing on the web, there are no flaws in it, go ahead. That would be a high value service that could be definitely useful for this kind of name. And yes, what do you think, Jeff?
Yeah, I mean, look, so Assurant is one of those companies that it's like it's behind a lot of warranties. So like you get a warranty at Best Buy, it's actually being provided by Assurant. You get renter's insurance from um, one company, or you get it from like a real
Geico.
estate company. It's Assurant that's providing it on the back end. So um, that's I think AAA they provide a bunch of insurance for. Uh, so they're not like the front end. You don't like. I guess you could, in theory, go to Assurant and buy insurance directly, but they specialize really in doing warranties and other kinds of services like B2B wise. So they are really well known here. Um, they're certainly, if you look it up on Google, I think every single search that's not, or every single page of the first 5 pages have to do with them, unless it's like a sponsored search that happens to have paid for a keyword that's not them. But yeah, so all the organic searches are really about them. I think also T-Mobile uses them as like the warranty provider. So I mean, this was look. You can't expect to win a case like this if you're not going to respond. You just can't. Not with a large company. Certainly not with someone like. Uh, oh my God, why am I totally blanking on his name?
Gigalaw.
Gigalaw. Yeah, Doug Eisenberg. Um, so he's very experienced at this. He's also a panelist. He represented the complainant. So he's going to put together an airtight case. He's going to put together the information that you need to find that this mark is well known in accordance with like the Telstra passive holding. And so, um, like I said, maybe there were things that this registrant could have argued, but at the end of the day, um, if you're not going to make the argument, you can't expect to win against a large provider like this.
This would have been a perfect name to respond to, because as I look again at the definition of the Old English, giving assurance, providing confidence, and with AI, that's like the big thing now. There's some websites I know going up to show this is an actual picture that's on chain, a real photograph that was taken, not some AI generated image. So to give assurance in the age of AI, to provide confidence in that, makes a lot of sense. So someone could have really provided that, explanation for here's why I got this, and it wouldn't have been easy. You see a domain name lawyer who's very familiar with UDRPs, Doug Eisenberg, and written books on these topics, but definitely a big brand attorney coming at you. Well, still, this name assurant.ai, this is actually one of the ones, this word, unique word, makes sense with the .ai. So what a great one. Here's the greatest reason to have defended it and been successful is, of course they're interested in it. Of course they would have then they come knocking and you're like, of course you want it. It's your company name, but this is a beautiful word too. It's just like if Purple, the mattress company, if they start, I don't know, I'm just saying a name that someone would absolutely have the rights to own. But when you have a $1 billion company that's named that, you love it. And you're thinking, you have rights to it. If you would have successfully defended it, then of course you can be patient and wait around and let them come back, negotiate with them and know, yeah, you probably can't afford more than 4 figures for this. But I mean, it would have been nice to have seen an answer and, still had to work to be successful. Okay, we have nobody with their hands up. If they want to say anything, make a comment, we're going to be open for another.
I had a quick question,
good.
Todd.
Thank you, Paige. I did see your hand, but I wasn't sure if it was stuck.
A short answer for today, but maybe put it on the calendar for the next show. The idea that the respondent is name admin, I guess that's because before the complainant files the UDRP, they can't find out who owns the domain name unless they've done it through their own research, right? They can't find out who it's going to be. But then obviously when they they file it with name admin, but then when they get the response, that's where they get a chance to find out, like say it was me, who I am, and then they can go there and get all the skeletons out of my closet. Is that about how it goes? Is that when they file, unless they've been able to ascertain the owner, they just have to put can they find out who owns it through the UDRP process?
Yeah, so when you file a complaint, absent knowing who the registrant is from any other source like the website or whatever, you generally now you'll only have redacted information. So usually it will just be against the privacy company that the registrar uses. But once you file the UDRP complaint, the provider then sends you or sends to the registrar a note saying a UDRP has been filed, lock down the name, and give us true information of who owns the domain name. Then the provider gets that information and sends it to the trademark owner that filed the case and says, hey, you have a chance now. You can amend your complaint. You can, put the new information that you see in there. Maybe, you have some additional facts about that person now that you know who it is or that company. And so you have an opportunity to amend it. Not everyone does amend it. And frankly, sometimes, and we've seen these cases in this room, where that once the information is revealed, the complainant should have pulled the complaint because, its last name matched the domain name, or because they found out who it was, and sure, that party has a right to the name. But there's no incentive for complainants to actually withdraw their case because either way, they've paid all the money. They're not going to get a refund, and you might as well see to it till the end. So, yeah, that's how it works. But a lot of people still have domain admin as the name of the registrant, like domain admin at a certain company, because they don't want to put personally identifiable information in the who is because of GDPR. So even if you find out that a large company, Assurant, owns the domain, it still may be something like domain admin or information security rep or whatever, because they don't want to list an individual person.
And as far as you know, is that okay? Again, not specific legal advice. It's in good. I always didn't want to put name admin because I thought somebody would like challenge my who is and say, oh, see, no real person owns this name, delete the name or something like that. And I'll keep going. The reason I was asking to bring up Todd, GoDaddy just changed the who is rules, and I really asked James Giles to do more work on this because I think that
Sounds like your
teams have
mic's
a
covered now, Paige.
okay, someone's got the rain, it's raining somewhere.
But
Yeah, we can't hear
David,
you,
answer what
Paige.
he was saying there. You know what he was talking about.
Yeah, I got the gist. I mean, you can use domain admin, and most of the companies do, but you still understand who the company is behind the name, right? It'll say registrant contact domain admin and the name of the company. Um, I wouldn't just use domain admin um, as because if you're selling names, you want people to be able to contact you, number one. But yeah, I understand you might be afraid of a UDRP or whatever. Um, but UDRPs, if after the information is still released and the only information you learn about the person who owns it is domain admin, you don't even have a company or anything else, then that's going to be seen as you trying to hide your information. So that's not
So
a good
Jeff,
thing in UDRP.
the reason why anything Inc. uses that is because it's a virtual corporation that owns a domain name portfolio. And so the person who owns it is anonymous because it's St. Kitts or Cayman Islands. They have corporate secrecy there. So you don't want your name there because then you have to
Well,
pay
no, I mean,
taxes
that's
personally.
okay because they also have as the organization anything.com. That's fine, right? Because you could tell from other information in the who is who it is. But if you're just an individual person that owns a domain name and all that's at your contact once it's revealed is domain admin with no other hint as to who you are, that's not a good thing. That's not seen positively in a UDRP.
And that's
But if
what I was.
you're, yeah,
What I was thinking was because I know the organization field now takes on increased importance. It seems like in the new who is world because that is potentially viewable. That organizational cell, for lack of a better word. So I like the idea that if you're going to use name and admin, definitely have the organization, even though that's not what you said, but that's what you hinted at. So thank you.
You need
yep.
to, Jeff, hold on. You need to.
And also, just to correct something, with WIPO, you do get a refund if you withdraw your complaint before a panel is appointed. So it's not a complete refund. There's a processing fee that they keep, but if you don't remedy your deficiencies, then it's going to be deemed withdrawn also. So they look it over and they process it initially.
That's true. The forum still doesn't have that refund, but yes, you're right. The WIPO does offer that, and so there is a little bit of an incentive. But again, like we talked about last week, right? The respondent in one of those cases last week didn't let them withdraw because the respondent could say, "No, I want to proceed to a decision." And in that case, doesn't matter if the complainant wants to withdraw even at WIPO, it'll go forward.
Right, that was
But
James
I
Booth.
guess if it's before the registrant gets served, then yeah.
Yeah, that was James Booth. Zach was defending James. But Paige, you're right on it that a registrar can suspend or cancel a registrant a name if they feel that there's fake who is information. So that's why you have to opt in, I believe, at GoDaddy to say, yes, please show my organization, because now it by default doesn't show your organization unless you allow it to. I don't know about other registrars, but it is, we haven't really seen people, and Paige, you've been doing it, as long as anyone and mess with every registrar. We don't really see them take away names, suspend or cancel, but they certainly can. And if that happens, you don't want it to happen one time because you have domain admin, but yet we saw in the three cases today, domain admin was, first the name that the was given to the complainant, and then sometimes, like Jeff said, the complainant gets the full name, but they don't amend their complaint to include it because they're like, hell, we'll just keep going forward. I wanted to mention quickly that I said what was Jason Schaefer and John Berryhill. If you want to meet those two guys, you want to meet Jeff, you want to meet me, We're going to be doing some things down at NamesCon, so you can always, basically, I think they're going to, let me use this code for a little while longer. It's capital letter speaker 20. So if you are going to sign up at NamesCon, you want to go get a ticket, you'll get 20% off. Use the code speaker 20. That's going to do it for today, but I did want to remind you one more time. I guess in about, when was it? So that would be 2.5 hours at 4 p.m. Pacific today. That's 7 p.m. Eastern. There's going to be a live domain auction here on X. It's going to be fun. There's going to be some names, as little as 20. Arif had some the other day that he was going to drop, that he was offering them for $5 if you paid the renewal. And believe it, I think Ish picked up quite a few, and a few others did. But, like I said, somebody's trash may be your treasure. But then there's also plenty of names that people were, like myself, were planning on renewing. And I start the bidding at $50, $100, just to have some fun. And then some names that are, I'm not going to mention the ones I sold last week for $75 because they're adult names. No, they were cannabis related, but none of your business. If you want to, look on my timeline, you can see a link to this room that's later today. I hope everyone has a great rest of your day wherever you're at. Next week, I'm going to be in the Midwest doing some farm work, but I'm going to be here Tuesday. Yeah, I can still do it. So check us out here, Domain Name Law, every Tuesday, noon Pacific, 3 p.m. Eastern. Even if I wasn't here, the other guys, that's David and Jeff, would handle it. But I will be here next Tuesday. And then, of course, after that auction today, I'll see you guys later. But then Thursday, join me and Josh at 10 a.m. Pacific. I'll be back in the Midwest. So good, I get to do it at 1 p.m. this Thursday, 1 p.m. Eastern, the DNX show. And we have a lot to cover. Check out Josh Reason's X account. He's been bringing up a lot of different topics that we're going to touch on. That's his username is at josh.com. You can find it also on my timeline. But that's this Thursday show for domain investors. Check us out. Till then, see you guys later today. That's it for the rest of today. Take it easy.